Hi, this is Arun Bhaskar from BKBB, which is an acronym for Bhaskar Ki Business Baatein. We normally focus on policy analysis, conversations, and an occasional story. This time, we have two of them rolled into one, policy analysis as well as a conversation. And the two experts on my group today are eminent lawyers. I couldn't find anyone better. And they are Mr. Advocate Bhargavan as well as Advocate Trivedi. Welcome, Bhargavan and Trivedi. It is great to have you here. And what we're going to discuss today is something that is so important to any developing nation and even for developed nations. Nations grow if your competition law is in place and working and fit. When the competition law starts getting queered, it allows for rigging the game. And while I'm not a lawyer, I know that competition law needs to be worked on. And recently, the Supreme Court came out with a judgment that is just brilliant. And to explain the judgment, I have both these gentlemen who are going to try educating me and telling you what the law is all about. I'd leave the initial stages to just a 3-minute introductory opening remarks, and then we'll get into a discussion altogether. Could I request Bhargavan to start his to give the opening remarks?
Thank you, Mr. Bhaskar. Thank you for having me. I am not sure about eminence, but clearly I'm a student of law, and I've had the absolute privilege of working alongside Utsav and some fantastic people. Right, this was a big caucus, right, on both sides, and I think everybody endeavored and persevered. And what came out was brilliance from the bench, brilliance that has relevance both to economics and the law, and just a privilege to actually have witnessed it. And I'm grateful that I can actually share some of what I experienced here purely as a student of the law. And so far as the judgment is concerned, I think it touches on two really fascinating aspects. One is the Insolvency and Bankruptcy Code, and one is the competition law. Clearly, since you mentioned the competition law, it does some, I mean, it gives a lot of clairvoyance into the most intricate and significant part of competition law that deals with combinations, that is Section 29. And it lays down why some of the sections that are in plain meaning are so critical to be read the way they are supposed to be read. I'm looking forward to this conversation with you and Utsav, and hopefully I'll be able to meaningfully contribute.
Could I request Trivedi to come in and talk about his opening remarks, and then we start a discussion casually among all of us?
Hi, Mr. Bhaskar. Thank you so much for having me here. It's truly a pleasure to be able to speak about a matter which we have lived and we have, we have worked very hard on for the past 3 months. And it's really a great judgment which has been given by the Supreme Court. I must tell you that this is the first judgment by the Supreme Court on combinations under the competition regime of our country. As you're aware, and I'm sure as your viewers would be aware, the competition law in our country is split into two parts. One is the adjudicatory function, and the other is the regulatory function. Insofar as the adjudicatory function is concerned, which is managing the cartels, punishing the cartels, and anti-competitive agreements, and second is the abuse of dominance. We've had some great judgments insofar as the adjudicatory powers of the Competition Commission of India is concerned. But this is the first time when the Supreme Court has actually come forward and passed a judgment on the regulatory aspect of the matter. Now, according to me, and I mean a lot of other people also, uh, regulatory functions are the foundational premise on which the Competition Commission was actually established. Unfortunately, I think it was 2-3 years later when the combinations were actually notified in 2011, if I'm not wrong. The Competition Act, even though enacted in 2002, the Section 3, Section 4, which deal with the adjudicatory power, were notified in 2009. And for 2 years, there was a vacuum insofar as the regulatory aspect of under the competition law was concerned. But from 2011 till 2025, I must say, the Competition Commission was running the show as per what they wanted, without any regard to the letter of law. Anything that was written by the parliament was diluted. I should be very blunt about it. It was diluted under the regulations, and they would just do as they please because regulations were enacted by the competition they were delegated legislations. They were enacted by the competition commission, and they would just dilute uh, provisions without the parliament passing any law. And now, finally, the Supreme Court has now, for the first time, come down heavily on them. This is going to be a great, great welcome change. The Competition Commission finally has been told to toe the line of the law. So, yeah, on that note, I mean, this is really, truly a landmark judgment, and I hope first of many to come. Thank you.
Thank you for the opening remarks. I'm sure everyone who's watching this channel will be eager to know what were the major points the Supreme Court made. And it's open to both gentlemen.
Utsav, do you want to go?
Uh, I'll cede to you, Yadunath. You should start. I'll join in.
Thanks. I think Utsav set the tone really well, Mr. Bhaskar, right? I think for a podcast like yours, which basically is on the cusp of economics and today the law, I think what is fascinating was if the provision that is discussed in the judgment, right? That is the both in the case of competition, both the majority judgment and the judgment which was minority, right, of Justice Bhati, is Section 29 of the Competition Act. And of course, Section 29 is directly related to the previous sections with respect to, when an application is made and how it's considered and how an inquiry then culminates into an investigation, right? But just to basically pick up on Utsav's tone, I think what was shocking, quite frankly, was the way the Competition Commission was essentially using the law, right? So if you look at the antecedents of the law, the antecedents of the law essentially has place in constitutional principles. Okay, and it's a social welfare legislation. And in fact, just Mr. Dushan Dave had espoused the sentiment before the honorable court, right? But what the Competition Commission has done is it's actually taken social welfare legislation and completely ignored the parts which are safeguards to social welfare, right? And that is just shocking. And this is since its inception, right? And that was what was shocking to us as students of law as we were trying to espouse this before the bench. And I think the majority and the minority, so far as the Competition Act is concerned, picked up on this sentiment, right? So what was it that they were not doing? Right. Section 29 required that a notice be given to both parties. Now, the significance of a notice in Indian jurisprudence is huge, right? Various judgments have reinstated the importance of audio alteram partem, which is that all parties that are required ought to be heard, without which the entire judgment is perverse, the entire process is perverse, anything that comes out is perverse, right? I mean, you just can't test the sanctity of the outcome without actually having heard the party who was relevant. And in this case, legislative wisdom required that both parties be heard, right? And what was fascinating here was that they went one step further. What was it one step further? The one step further was that both parties ought to have made an application together after having been heard, right? And even in this case, it was just one party whose application was entertained, right? So you essentially made a mistake and you double down on that mistake. And what's even worse is you come to the Supreme Court and you try and support the mistake, right? I can understand if you made a mistake and you say, okay, we made a mistake and the court's asking of us and we are going to be actually honest about this. But the Competition Commission acted very curiously in this case. And for all of us who are students of law on both sides, Right. It was fascinating to actually see this play out in court, especially when the underlying legislation is social welfare, right? Is this anti-business? No, it's not, right? Because yours is a policy podcast, a business podcast. It's not anti-business at all. In fact, do you want companies to be competitive? Yes. Do you want combination to go through? Yes. But for whatever it's worth, when the legislature says that you essentially have to do something, which is give notice to both parties, I don't think it's up to the Competition Commission to decide whether that's a good or a bad thing, right? That is the job of the legislature. And what this judgment very beautifully says is that, listen here, our job as a court is to read the law and read the plain meaning of the law, not actually introduce intelligence into it that the legislature specifically told us not to, right? Because, reasons can be many. There can be for reasons against reasons, right? And therefore, under these circumstances, the way we read it, I don't think we can come to any other conclusion that you guys didn't do what you're supposed to do. And so, to us, it from a competition perspective, some major gains have been made in both the majority and the minority judgment. Let me see to Utsav and then perhaps combine.
Yes. No, I mean, Yadu sir, just to add on what you said, I mean, it's not just a question of misreading the provision, justifying it in court. In fact, if you see systematically what is happening is that this misinterpreted provisions were actually giving sanctity by the Competition Commission by enacting regulations. Now, there is a regulation called 25(1)(a), which is in the teeth of the entire Competition Act. There is no provision which supports 25(1)(a, but the Competition Commission wants to do certain things and then they would enact regulations. Yes, Mr. Bhaskar, you have a thought.
I just wanted to ask you, I've got two very interesting statements made by the Supreme Court, and then you could dwell on those two statements also because those are very interesting statements. And since you could read them and then tell everyone what these judgments are.
So, Mr. Bhaskar, I mean, if I may just take 30 seconds of your time, I mean, this, I'll tell you, this is not really something new that Supreme Court has said.
Okay.
This interpretation of law has been in existence, and while we were researching for the matter, we saw right from the Privy Council days these judgments are being written. The most shocking part, so I'll share one small anecdote. When this matter came to me, when I had to read up the matter and get ready, I only got involved at the Supreme Court stage. What was shocking to me was the fact that we are the appellants and that we have lost the matter in two courts below. As you are aware, this matter is with respect to IBC as well as Competition Commission. Now, we will go to that provision of IBC, the Insolvency and Bankruptcy Code. And I mean, even any non lawyer will read that and will say, yes, what we were saying is right. The cause that we were espousing was absolutely right, but we were the respondent, we were the appellants. We've lost in two courts below. Similarly, if you see the Competition Commission, I mean, the number two player is buying a number one player, is taking over number one player, violating all provisions. There is no way, in my experience, in such extreme facts, that I have been the appellant. I mean, I don't want to go into why I was the appellant. I mean, for whatever XYZ reasons. But the fact that number two is taking over number one in certain segments, the monopoly reaches 80 to 85%. And we are talking about glass, Mr. Bhaskar. Glass is the only alternative of the biggest problem in our society, that is plastic. You are talking about glass, 85% will be monopolized by one entity, and there is a free pass. We are told by courts below, no, we will not sit in appeal over the the wisdom of the Competition Commission, which the Supreme Court found there are major problems in the discrepancy. It just appears to be the case that yes, we have to promote competition. Unfortunately, the Supreme Court reads competition as being overtly business friendly. We will let everything go through. I mean, the moment you have that, then might as well shut shop, and I mean, then let everything else happen.
Second
That's
case.
all.
Okay.
So,
Can I take the second statement that was made in the court by the court? Here's a second statement that I found very, very meaningful. Could you dwell on it?
Utsav, do you want to go? Oh, yeah.
No, I mean, this is just in continuation of the last one. And if you see, this says language is unambiguous. That's my IBC point, my Insolvency and Bankruptcy Code point. Once you read the provision, Mr. Bhaskar, you will be shocked that we were the appellants. Mr. Bhargavan, will please, so please start.
If I can, thanks, Utsav. So I think the first quotation that you showed, the first quote and the second are in the same spirit, right? And I, no pun intended. Um, what the judge has said in both these quotations or quotes is that if the law is simply read, I mean, if the law is rather the law ought to be read the way it is stated, right? And so I've just pulled up those quotes. The first one says, "The spirit of the law, well, may be an elusive and unsafe guide, and the supposed spirit can certainly not be given effect to in opposition to the plain language of the sections of the Act." Right? Same as the sentiment in the second quotation. So what the judge is saying is that the spirit of the Act, when you actually argue a case, right? And you are pushing, and this is the minority judgment, when you're pushing for a law to be read purposively, that is other than simply, right? And in this case, notice to be given to both parties, or rather that the the CCI approval shall come before the COC decides on the resolution plan, right? So when the legislature is very clear about the language, right, then it is not for the courts to then come up with a another interpretation or a construction basis an argument that it's inconvenient to me, or it could perhaps be inconvenient to a class of people. So what the first quotation says, and the second quotation carries forward, is that when it's inconvenient to a class of people, it's convenient to a class of people, right? So that balancing is not for the courts to do, it's for the legislature to do, right? Now, if the legislature leaves it ambiguous, correct, then the courts enter that domain. But when the legislature does not leave it ambiguous, and to Utsav's very important point, it's a social welfare legislation, right? To then ignore the absolute language of the act is very, very problematic and creates distortion in the law, because at this point, you will have 5 lawyers say, you know what, this is okay. And you will have 5 lawyers say, it's not okay. And that's not how you want the law to be. You want the law to be finite, right? So if you talk to the other side, and I would encourage you to, they will say, we got legal opinions from the biggest and the best. And I'm just going to carry Utsav's point further, that in fact, two courts below the Supreme Court actually agreed. And they agreed against the absolute clear language of the legislature. And that does huge disservice to jurisprudence. Because at this point, it's a free-for-all, right? So what Justice Roy has said is that when the language is clear, it's not for me to sit down and figure out, which class it's inconvenient to. Now, if you get into facts, you would realize how difficult it would have been had you basically provided purposive interpretation. Had purposive interpretation come in, right, it would have completely killed 2 sections, right, and blown through safeguards, which otherwise the legislature intended it to be there. Let's assume that you don't want those safeguards, right? You go back to the legislature, and that's precisely what the majority judgment says, and let them change it. They're entitled to, right? And then the courts will essentially test whether those safeguards ought to have been there or not. And that's how a disciplined jurisprudence should evolve. What was even, hilarious for people on this side, also myself and all the seniors, was that they didn't need to go into previous decisions, the adjudicating authority in this case had specifically told them to follow 31.4 proviso in its letter and spirit and get the permission prior, which they
Yeah.
curiously ignored. And they decided to get a legal opinion and go here and there, right? So, this is the danger with not following a statute which is as clear as day and night, right? In terms of an exception. So it was very interesting from as a student of law, and so that even though primarily the this particular court, which is from the minority decision, it is great wisdom in normal circumstances. In this particular instance, the reason it perhaps didn't apply, in our opinion, as much is because of these three criteria, right, that I just spoke about.
Just 1 second. Can I show you some of the provisions that we have managed to put together? Could you tell us in what areas has this law changed all prevailing judgments?
Yeah, so see, this is actually in continuation with what Yadusa was saying. The first provision is, even though the section is not mentioned, it's 31.4. It When the IBC came, it came with 31, actually till 31.3. There was an ordinance which came in, I think, February 2018, which added this first row, which said that all the approvals have to come within 1 year after your plan is approved by the adjudicating authority. This obviously was a mandatory requirement. You have to get it, and the law was very clear. Then, I mean, after 2018 February, there was an after ordinance was repealed by a bill. The bill was thereafter passed with certain changes. And if I believe, I think sometime in March or April or May rather, May 2018, 31.4 was added, and thereafter the 31.4 proviso was added. So the bill had 31.4. The act, the amendment bill, which was eventually passed, had a proviso. Now, this proviso was quite interesting. This proviso said that insofar as it actually, it sort of provided a carve out. It said everything else is important but can wait after the adjudicating authority, because ultimately the function of IBC, the most important, the most important objective is for a resolution of the corporate debtor, and everything else can wait. But the legislature, in its wisdom, said in the proviso that everything else is fine, can wait. But when it comes to the competition commission approval, you have to get it even before the stage of COC. So, as we're aware, under the IBC, first you submit your plan, then the plan goes to the COC. COC, votes on it. There are certain changes, whatever you want to do. Then the COC finally votes on it. The plan is approved. The best plan goes to the NCLT, which is also known as the adjudicating authority, and that's the scheme of the IBC for approval of a plan. And then the adjudicating authority approves the plan. So within 1 year, you can get everything else. But insofar as combination approvals under the Competition Act are concerned, you're supposed to get it before the COC votes. Now, the reason which the Supreme Court, this was an argument which was raised by our side, and which found merit by the Supreme Court, and the Supreme Court upholds it. It says the reason appears to be that the Competition Commission, see, if you go with a combination, the Competition Commission can say, look, you can't buy five plants, sell one of them. There will be a modification to the resolution plan. So, which power is available to the Competition Commission? Now, if your plan stands approved by the COC, the law is after COC, adjudicating authority is just a stamping authority. It cannot enter into this renegotiation, etc. So the legislature, in its wisdom, felt that once the plan is up to the COC level, all modifications can be carried out, if at all suggested by the CCI. Subsequently, the plan can be voted and can be put before the adjudicating authority. This was the spirit of the Section 31 for provision. But as in practice, everyone till now believed that even after your adjudicating authority approval, or even after you file the plan before the adjudicating authority and the COC has, approved the plan, you can get the approval even subsequently. The entire objective was lost by this unnecessary dilution of law, which is what Supreme Court has finally corrected. And that's why I said it was shocking to read the provision and to know that you have lost in two courts below.
Then, now that the judgment is out by the Supreme Court, will it have a prospective effect, or will some of the cases decided in the past also get reopened?
No, 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 no. It'll be a perspective. I think I think that's pretty settled, right? And what's interesting from a Competition Act perspective is, um, I think that the law has already been amended. In fact, there was some confusion while we were arguing the case because there were different books floating around. Now, from a 31-4 proviso perspective, IBC, it's the rarest of rare cases that actually require in the context of IBC a competition commission approval, right? These are only cases which essentially beat the threshold of 15% market share, and you go to AAC. But after that is only if this is significantly going to have an
Yeah,
impact on market, right? So from a prospective perspective, I don't think this is going to upset the apple cart. And if somebody says so, it's just rabble rousing, right?
yeah.
I think
E-
this is a beautiful piece of legislation that the court has essentially. I mean, what they've done essentially is not legislated; they've actually stated the law the way it is. That's the beauty
Yeah,
of it.
yeah.
In fact,
That's the correct. That's the point.
they essentially look at the law of interpretation. There's an entire treatise on how to interpret laws and why, right? And I think that's the beauty of it. Just to build on Utsav's point on 31-4 proviso, right? I think what's fascinating from a law and economics perspective is, right, if you essentially take out four, right, the amount of problems it creates between the two sections, two acts, right? On the one hand, you have a special legislation in the Competition Act, and on the other hand, you have a special legislation in the context of the Insolvency Bankruptcy Code. Both of these legislation, being special, supersede other legislations, right? They have overriding provisions. So that proviso actually was a carve out for a specific reason. The legislature had specifically carved it out, so there is no conflict. The minute you remove this carve out, you automatically introduce conflict, right? So by essentially respecting the sanctity of that carve out which the legislature has introduced, I think the honorable court has in fact respected the legislature for its wisdom.
Yeah. And just to add one thing to what Yadu sir just said. See, usually the law is that unless the court says otherwise, the interpretation is merely declaratory and has to apply retrospectively. Unless stated, the unless stated in the judgment itself that this law will be prospective in nature. But as Yadu sir said, this is an extreme situation. Mr. Bhaskar, we analyze everything, we analyze specific cases, and we spend nights reading the competition commission's uh, annual reports. And the annual reports have clearly said, how much time usually the competition commission takes to approve combinations of this nature? 1 day, 2 day, 3 days. There are 14 days. The average time by stated by competition commission is 17 days. This includes this, let me tell you, this includes all the matters where the time taken is more. But I mean, that's one of the things that weighed with Supreme Court. They said this is an extreme situation. We are not the problems that were espoused on the other side in the working of the two legislations. The Supreme Court said in this extreme situation, we are not going to dilute the law for one off case. And be that as it may, as Yadusa said, now I don't think, even though it applies retrospectively, I don't think there is even one factually subject to correction. factually, I don't think there is any place where the CCI approval would have come later and would be stuck at a stage where this law can be, you know, applied and things can be changed. So, yeah, I mean, that's the.
Indeed, a very, very interesting law. And I'm glad you raised this. I'm glad you
Yeah,
explained it to us because this could actually pave the way for a healthier economy and a genuine approach to competition.
in fact, yes, it basically creates dependability, right? Which is obviously the best thing for economy, right? When you talk about law and economics and policy, is that now you read the judgment the way it is. You say, look here, you need to have this permission. It's pretty easy to get. To Utsav's point, you get it in a day, you get it in 2 days, assuming you're going to create a lot of adverse effect for competitions. Clearly, you have to go through a process. You got to give these. You have to go through an investigation. You have to basically talk to the public. You have to tell them, hey, this is what needs to be done. And
Yeah.
it might be inconvenient, it might take a few days, but it's not going to upset the process, right? It needs to be done because that's the carve out. And that's the job of the competition commission, you know. So I think it's time that competition commission did its job.
Yeah, and I mean, just one to add one thing to it. I mean, see, the problem that was, spoused on the other side, which was put into limelight by the other side, that the competition commission is likely to take more time. The IBC is a time-bound process. It can be in a conflicting zone. Well, I mean, if that happens, if the Competition Commission of India is taking that much of a time, that means there are serious concerns of an AAEC. And then maybe we can't say the legislature was not aware of the provisions. Then maybe the legislature didn't want such people to come forward. For instance, if you see 29A, initially the ex-promoters were welcome. The legislature said, no, we don't want ex-promoters. Then they again came out with 240A that insofar as MSMEs are concerned, yes, the former promoters can put in a bid. But I mean, if there is a major monopoly concern, major competition law, antitrust concern, then yes, the legislature, that's how we should read the law. The legislature does not want these people to put in a plan. And that's exactly what Supreme Court has said.
Also, if I can, you know, so the legislature has no problem if they put in a plan. They just have to follow a process, right?
Yeah.
And that process is very time bound. It's not as if it's an open ended process. But to Utsav's point, you might fail in the process, but that's okay, right? That's the way things are.
In fact, thank you very much for bringing all these points to the audience and to me. It's a fascinating subject, and maybe I would like to be in touch with you constantly, even after the discussion gets over, so that I can understand a few more nuances of this judgment. But thank you very
Sure,
much
Mr.
for being
Bhaskar.
here. Thank
Thank you,
you
Mr.
for
Bhaskar.
elucidating these issues so wonderfully. It was meaningful, it was relevant, and I'm sure it'll mean a lot for the industry and the economy. Thanks again.
Right. Thank
Thank
you,
you
sir.
very much.
Thank you so much.
Thank you, Mr. Bhaskar.
Thank you
Thanks,
very, very
Utsav.
much.
Thank
It's a
you,
pleasure.
sir. Pleasure, sir.
Thanks for being with us. And do write to us in case you think there are some other subjects that you want us to cover. And do click the subscribe button. Do let us know that whether you liked it or not, the more you like it, the more numbers grow. And because of your numbers have grown substantially, we'd love to see it grow even further so that we can become more meaningful and be galvanized to offer more such topics to you.